over in ways that up until now we just have not had?
The answer to that question is a little bit complicated because we have, first of all, let me explain about this consent dilemma or the transparency paradox first. Because when we think about those terms and conditions that are very long and we are not quite sure, should we say agree or should we just leave that services? Some say that we should make it more comprehensible, make it shorter, make it clearer, make it more understandable. But at the same time, with that clearer, with that clarity, you lack some information that actually very important. So how should we get around this notice and consent issue? Should we get it comprehensible or should we get it comprehensive? So it is very, this paradox always with us all the time. So then, as you said, the current privacy regime is based on the self-management of privacy. So we believe that everyone should have rights, should have autonomy on their own, either to give away their consent in trading off with other continents or anything. It should be your choice. So it's depend on these. But the problem is that we have limited capability for each individual subject. Not everyone, first of all, not everyone can read those 200 pages English terms and conditions of iTunes. Those who use it just click the button, or even those who can comprehend all of that, still, you have so many devices all together, you cannot manage all of them, micromanage all of them at the same time. It will waste so many time of your life. And at the same way, the companies, they also have limited resources to get your consent. So the best way they can do is to get the consents for everything they want. So it's gonna be, at the end of the day, it's gonna be the blanket consent, which is not good for your choice. This is not good because it does not specify what kind of purposes, what kind of use is gonna happen. And then the last one, the inability of the society as a whole to predict the future use and the future effects of the use of our data in the big data era. We don't know how this technology will release up to. So no one knows. So no one can provide a very good model for the consent or notice. So then the next question is that should we move away from the self-management, the autonomy regime, to the more paternalistic approach? Should we have the law saying it all? This is the model of privacy policy it should be. This is the use of data, of personal data that are allowed. So should we believe that in the government-led policy or government-led approach? My answer to this question is yes and no. No, because we still should have autonomy, our own decision. We have different preferences. We have different tolerance level toward advertisement, toward intrusion of privacy, and we have different lifestyle. Those who work as data engineer, they should have more, of course, they will have more awareness, they will have more preference. But those who work for example, entertainment industry, they might not care. The privacy might be a commodity, and it is their choice to do so. So I think but at the same time, there might be some line that we as a society should draw some rather, I cannot say clear because it will never be clear, but some line that as a society as a whole we should help to protect. For example, the privacy of children, the privacy of teenagers, those kind of those areas, it can be somewhat paternalistic. And being paternalistic is not that you set all the models and you let everyone follow these models, but it might be something that you urge people to think more about the privacy within that architecture. I might refer to the nudge theory by Professor Taylor, who just got the Nobel Prize from the economic branch, that sometimes government do not need to force everyone to follow a good behavior or good model. You can nudge people to think about the choices that they have. So maybe the privacy law in the future should be more balancing on desirable privacy management and individual choices. So that would be the task for the privacy law in the future. And actually, we have some business right now that trying to offer the centralized management system for each of us. For example, you can have, like when you surf on the website, you can have this app and setting the rules of yourself that this kind of information I can give away to this kind of website. And this kind of information I will not give away to any website. So for example, every time you use the new application in Facebook, you do not need to click on those terms and conditions every time, but you can have this app help you to manage. And they even have the new company trying to combine your data set with the services. For example, if you are okay about giving away your personal data about traveling preference to the airline company, and then with that, you can get like 30% off directly from the airline company, not by the advertisement. So there is like this kind of service that trying to link between the monetization of your personal data, but with your own decision, with your own choice. So this kind of technology might help as well. So the other solution might be more substantive rule of privacy. The rule about consent and notice is procedural. Whatsoever consent you give, we don't care. We care about the existence of consent or not. But the privacy law in the future might be more substance oriented, such as providing some standards for obfuscation or cryptographic standard. And this is the area that privacy law in the future will come across with the cybersecurity law in a very close relation. So I think I will just stop there for the first one.
So we'll move on to Dr. Lasser. Dr. Lasser is a lecturer of law at the Faculty of Law, Thailand University, and is also a member of the German Southeast Asia Center of Excellence for Public Policy and Good Governance. Now, Ajahn Lasser will be covering the constitutional framework for restrictions of the right to privacy and the freedom of communication.
Right, okay, thank you very much, Smidis, and welcome also from my side. I'm very happy that I was invited and have the opportunity today to also give a little bit of an insight into the public law dimension of this topic. But actually, Ajahn Ging has now already laid a very firm groundwork, and it might in part be repeating what has already been said, but I try to make it as interesting as I can. So for the scope that I would like to cover now, I would like to take a look at the issue of cybersecurity and computer crimes and privacy from the perspective of those interventions with privacy where consent has not been asked for and where no consent has been given. So that means in the situation where the state intervenes with individual rights, in this case privacy, without asking for consent. In the case of, for example, prevention of cybersecurity threats or to investigate computer crimes. These may be situations where state officials, state agencies may access individual data in order to then, for example, prevent certain threats. Now, the question that always then is asked is, can that be allowed? So how far can the state go? How deep is the state allowed to go in terms of having access to individual data, personal data, to prevent these kind of threats or to investigate these kind of crimes? Now the bottom line to that answer basically lies very much in the question, which role do individual rights generally play in a given legal system? So, in legal systems where individual rights are very much at the center of the whole legal system, there the answer will very often go into a direction which says, well, we have to be very careful about accessing individual rights. We have to limit it as much as we can. And we have to make sure that the data is, you can say, controlled, and that also the access to the data is also limited. On the other hand, so that is maybe, you can say, the perspective that I bring from my home country, from Germany, but also from the European Union, where individual rights are at the very core of the legal system. And that results the answer to all these, or that influences the answer to all these questions about how far can we go. Because the background is, which role do individual rights play? And if they are at the center, then that already leads to the, you can say, result in many cases that it will not go that far. On the other hand, in a legal system where individual rights have traditionally never played a big role, where they have been laid down in the Constitution for decades, but where they have not really been, you could say, exercised and not really been used by the courts, for example, there also very often then the answer to this question, what shall be allowed, will be a different one. It will, much more will be allowed because individual rights are not so much in the center of the thought process. So, therefore, my task now is not so much to assess whether the current Thai legislation is good or bad. What I would like to do now is I would like to basically bring up some questions that we can ask in order to assess the current legislation that we have in Thailand, that legislation that is making it possible for state agencies to access individual data and personal data. But again, we always have to be aware of the fact in which legal system are we operating, and you come to different conclusions very automatically on the baseline of which role do the rights play in the whole legal system. If they have already a very weak role, then also the answers to these questions will usually be different than in a legal system where they have the very center. Now the starting point, what I would just like to take a look at is these two acts that we can talk about here. On the one hand, now the draft of the Cybersecurity Act, the current draft of 2017, and on the other hand, the Computer Crime Act, which has been amended this year in order to also introduce new measures, also measures in order, for example, to access data. Now, the difference between these two acts is basically what also our first speaker today has said. On the one hand, cybersecurity, or the measures connected to cybersecurity are measures about prevention. So the prevention of any cyber threats, also then related to that, maybe threats to national or military security. But that is actually one interesting point in the Cybersecurity Act, that the Act actually connects threats to national military security to cyber threats. Only those threats to national or military security which are produced by cyber threats shall be covered by this Act, not any threat to national security or military security. But the focus of that piece of legislation is prevention. Computer Crime Act, that is a classic, you can say, criminal law, you may say, which also has then other provisions, but the main focus is repression. So the difference between Cybersecurity Act and the Computer Crime Act is basically the one is for prevention, the other one is for repression. If already a certain crime has been committed, then the Computer Crime Act comes into play. So what kind of crimes are there laid down in the Computer Crime Act? For example, unauthorized access to networks and data, but also, and that is what makes this act, you can say, a bit problematic, also the upload of, for example, false or disturbing information is also covered by this piece of legislation. So it's not only about actions of unlawful access to networks, which is covered, but it is also covering for example, upload certain pieces of information, which is then also a crime. Now, from the perspective of interventions with individual rights, we would always have to look at what are the possible measures that the state has according to these acts. So what can the state do with regard to interferences with individual rights, in this case, privacy? And I just put some examples here which we can find in the Cybersecurity Act, for example, that gives powers to, for example, make any kind of order to any public or private sector member or to any person to comply with an order in order to prevent the cybersecurity threat from materializing. So anything that is necessary can be ordered. On the other hand, then also officials can access devices and systems. However, they will need a court order for that. So we can see there is a certain procedural safeguard here. Officials can also access communication information. That is, I would say, still a bit difficult to define what is communication information. Does that mean, for example, the content of that communication? I think that still needs to be defined. The Computer Crime Act also gives quite some access to data, for example. So officials can request traffic data, user-related data, can access computer systems, can remove or block content, and that is now also quite interesting, the Computer Crime Act also demands service providers that they must retain all traffic data of all users for 90 days. Of all, no matter whether somebody is under the suspicion of having committed a crime or not, but of all users. So anybody who uses a certain internet service, 90 days, all your traffic data, that means on the one hand, so that is true not only for internet, but also for emails, for example. So, for example, at what time have you been online? Which kind of emails did you send? At what time did you send them? To whom did you send them? All that must be registered mandatorily for 90 days, until it will be deleted if you are not under the suspicion of having committed a crime. Now, these are, you can say, the measures that the state has, although this is only a selection. These two acts even provide more possibilities, but these are now some examples where the state can access devices of yourself, your telecommunication data, your traffic data, and sometimes even the content of your communication. Now, how does that now play a role in public law? Well, obviously, all these kinds of interferences are restrictions of individual rights. In this case, the right to privacy, but also the freedom of communication, which are both rights under the Thai Constitution of 2017. So what I would like to do now is, I would like to basically provide a certain framework in order to analyze how far shall we allow the state to be able to access this kind of data. Again, my job here is not to somehow find a bottom line and say this act is good, this act is bad, but to provide you with the necessary questions that you may ask and that you may use them to analyze these two pieces of legislation with regard to the safeguards to protect individual rights. So when we talk about constitutional rights protection, my students will remember that we may always have the same frame to answer this kind of problem. So obviously rights can be restricted. There is, you can say, in general nothing wrong with restrictions. However, in order to make sure that a restriction does not result in a violation of a right, we would have to make sure that the restriction is justified. That means serves a certain defined purpose and also then provides, for example, for the principle of proportionality, which I will go into details later. So the steps to assess whether a certain piece of legislation, like for example the Computer Crime Act or the Cybersecurity Act, whether that legislation violates individual rights, we would have to use the Constitution as our frame. That is what we now check. We check whether the law is in accordance with the Constitution, and within the Constitution we take a look at the individual rights section and check whether any of these rights has been interfered with to an extent that we cannot justify. So first of all, we would have to ask the question, well, which rights are applicable? So which are the rights that we need to talk about now? Then we will ask, well, has any of these rights been restricted? That means, has it been interfered with? Which in itself is not yet the problem. The problems come then on the step number 3, whether the restriction was justified. Now, which are the applicable rights here under the Thai Constitution 2017? Well, first of all, Section 32, which is about privacy and the protection of personal information. Jan Ying has told us exactly what you can say privacy means and what the protection of privacy means. It is connected to a person, to the self-determination of a person, to determine him or herself which information of the person shall be available in the public. So the person should be able to present him or herself, and it should be the person's choice to decide which information should be available. In the German Constitution, we would always also connect that with human dignity. We consider it a part of the dignity of a person to be able to determine and decide for him or herself what should be the reputation and the image of a person in this society. With regard to privacy, we may differentiate between different spheres. I will go back to that in more detail when we talk about justification, but usually we can differentiate different spheres of privacy. Whereas the intimate sphere is maybe you could say the absolute core of your inner secrets and the things that you do not want to share at no compromise with anybody. When we would have the private sphere and the social sphere as you could say less protected spheres, we can make such a differentiation. I will come back to that in a moment. The other right that is applicable here in our issue, in our question, is Section 36, which is about the liberty and confidentiality of communication. This right is basically a specific form of privacy protection. So we call it a lex specialis, which means basically a special law. It's a subcategory of privacy. So basically you can say Section 32 already protects everything that Section 36 protects, but Section 36 is just, you can say, a specific kind of privacy protection. It protects privacy within ongoing communication, because that is particularly vulnerable for example, interceptions, and you would not have any control about these kind of interferences when you are communicating with somebody using some kind of communication device. That is, you can say, a very, very vulnerable moment for your personal information, personal data, and therefore it has received a specific protection under the Constitution, but conceptually it is also privacy protection. Another right that I would not like to go too much into detail now is, also Ajahn Ying has mentioned that freedom of expression, for example, plays a role here, and the press freedom also. So obviously also journalists use communication devices, for example, also when they communicate with their sources, so with people who give them information. And journalists are relying on these sources in order to always be able to, you can say, have some insights into, for example, what's going on in the government. They need these sources, and they need that the sources remain anonymous and are not, you can say, their identity is not disclosed, because then they may be subject to repressions and they may not be willing to talk anymore. So therefore also journalists would say we want our communication to be, you can say, protected and confidential, because otherwise if you monitor what we do, who we talk to, then that may, you can say, close off and cut off our connection to our sources. So press freedom plays also a role, but I will not too much talk about that. I will focus on privacy. Now, we have established which are the rights applicable here. 32, 36, privacy and confidentiality of communication. Now, all the measures that we have seen from the Computer Crime Act, from the Cybersecurity Act, all these are examples of restrictions of these rights. So in any of these examples, officials under this legislation are allowed to access data about communication, about, for example, the circumstances of the communication, but even also the content of that communication. And each of these measures, each of these powers that these officials have, constitute restrictions. That means every of these restrictions need a justification, otherwise it would be a violation of the Constitution. Every restriction must have a certain justification. So a restriction, first of all, we can define it as any intentional or unintentional hindrance or obstruction of the protected behavior or sphere against or without the will of the concerned person. And that already leads us now to what Ajahn Ying has also talked about in very much detail, the issue of consent. From a very, you can say, public law perspective, we can say restrictions can only be actions that happen either without the consent, or you can say, I mean, usually without the consent. So if we say it's either against the will or without the will of the person, then that basically means if a person consents on the basis of clear information, on the basis of the knowledge of the consequences of that consent, means if such a consent is given, we would usually not talk about a restriction. We would say then we don't have a restriction of a right, it would be a voluntary cooperation by an individual. So we are here indeed talking about restrictions either against the will of a person or without the will, if you just don't know that your communication is monitored or is put under surveillance, then it's just without your will, which would also be a restriction. All right, so voluntary cooperation would usually exclude a restriction in this perspective. Okay, but under these examples that I've given you under the Computer Crime Act and the Cybersecurity Act, all these measures would constitute restrictions as long as the person who is, you could say, ordered or put under surveillance, as long as that person does not consent. Now, we come to the most important step in our constitutional assessment, and that is always whether a restriction can be justified. So the justification of restrictions is always the core of our assessment under the Constitution. Now, the Constitution gives us, luckily, a certain frame that we can apply in order to make sure whether a restriction is justified or not. First of all, many of the rights granted under the Constitution stipulate under which conditions a right can be restricted. And that's very useful. We can use that, and we can use that as, you can say, the frame in which we operate. Some rights, however, do not provide that much information. And unfortunately, these two rights that we're talking about here leave it very broad under which conditions they can be restricted. So 32, privacy says in the interest of protecting a public interest, this right can be restricted. So public interest is obviously quite a broad formulation. And section 36, the freedom or liberty of free communication, confidential communication, does not give any standard under which this right can be restricted. However, the Constitution provides a general section about the standards that need to be taken into account for every restriction. Every restriction under the Constitution must at least not be contrary to the rule of law. That means have a clear and unambiguous legal basis, usually a parliamentary act. This clear and unambiguous cannot be found in the Constitution. That is my interpretation of what the rule of law means. My understanding of an act that is not in contradiction with the rule of law can only be an act that is on the one hand clear and also without any, you can say, without any ambiguous meanings. The other standard that needs to be respected by every restriction of any constitutional right is no restriction may violate human dignity. And we have seen that privacy is also connected to human dignity. It is, especially when we talk of very intimate secrets of a person, we might indeed connect that kind of information to human dignity. That there is, you can say, a right that such information will never be shared under no circumstances. And then finally, and that is very fortunate, and I congratulate the drafters of the Thai Constitution, that they have also included the principle of proportionality in section 26 that stipulates the general requirements for every restriction. So every restriction must be proportionate. The Constitution says it should not pose an unreasonable burden, but that is nothing else than proportionality. So every restriction must be proportionate. And that is usually the frame in which we can analyze here, the principle of proportionality. So human dignity, thank you very much. Human dignity is very rarely an issue. However, it might be an issue in this case with privacy. It's quite an interesting category. But our general tool to make sure that a restriction of a right is not violating the Constitution, the general tool will often be the principle of proportionality. Okay, so therefore, my students will hate me now, but public law is always about this balance between public interests and individual rights. That's basically our bread and butter every day in public law. And our major tool to decide whether individual rights and public interests are in a proper balance is our principle of proportionality. And I've coined a new term, I call it cyber proportionality, which I would say is the principle of proportionality in operation in cyberspace. I think also there, obviously, the principle of proportionality plays a very, very important role to make sure that we have a proper balance between, on the one hand, protection of privacy, and on the other hand, the protection of public interest. Okay, so it is very straightforward. Now my students remember all these steps, and I'm not teaching you these steps in order to torture you, but these are the real steps how to analyze proportionality. It's not a fake method, it is what constitutional courts throughout the world use. So obviously, the restriction must first of all serve any legitimate purpose. I've mentioned sometimes the Constitution may provide a purpose. Sometimes the Constitution says this right can be restricted for that and that and that purpose. Then we are very lucky. But as we've seen in our example here, might not always be the case. Sometimes the Constitution is just silent about which purposes are allowed. So we have to find a legitimate purpose. Then every restriction must at least be able to achieve that purpose. Otherwise, it would be considered a useless restriction. So restrictions must obviously be useful and must be able to achieve that purpose. Then they must be necessary. And necessary here does not mean, you can say, the government perspective. The government perspective is very often, we must do everything that is necessary to protect the public interest. That basically means we must do everything we can to protect the public interest. But that is not the perspective that we take here. Here we take the perspective, what is necessary from the perspective of the individual right. So we must choose that kind of restriction that provides the least restrictive measure. Yeah, so only that is, you can say, still achieving that purpose, but which is not violent or not restricting right to a unnecessary extent. Only that is considered necessary. Well, and then we might, in the end, also have to consider at the fourth step whether or not the balance between the public interest that we want to achieve, so in this case, cybersecurity, national security, military security, and on the other hand, the impact on the individual rights, whether that is in a proper balance. That is what we need to do. That is difficult enough. So the legitimate purpose I've mentioned, Section 32 at least says it must be done in the public interest, but actually that is something that we might already know. I mean, sure, in what other interest should the restriction be done? Sure, in the public interest. So it does not provide that much of a new information for us. So what can be public interests? Obviously, national security, military security, anti-terrorism, all public interest. Cybersecurity in itself, even if we don't connect it to military or national security, the protection of the cyberspace against intrusions is already in itself also a public interest. But then also we come to other terms like public order and good morals are also public interests, but we may already see now here a certain scale of public interests. We see here a scale of very important interests down to less important interests. And that plays a role for our balancing. So what may be allowed to protect national security may not be allowed to protect good morals. Because good morals may be a very broad term and nobody has really a knowing or understanding what that really means. Although we might say also national security might have different understandings in the ideas of different persons. If you ask a military official, he has a different understanding of what national security means maybe than a civil rights activist. However, the law needs to define that clear purpose. So if a law has a certain purpose, a legitimate purpose, then the law should also define what that purpose is, because only then we are able to assess whether the different measures that have been taken actually serve that purpose. If we don't know the purpose, we cannot ask whether the measures serve the purpose. We must know the purpose, and the law should stipulate that, shall tell us what is the purpose. Alright, but however, with regard to computer crime and cybersecurity, we don't have an issue with the legitimacy of the purpose. It is absolutely legitimate to protect cybersecurity, national security, military security. It's absolutely legitimate to protect also public order and good morals also. Absolutely legitimate, there's no doubt about it. The question is then on a later stage, how far can we go for each of these purposes? Now, the ability to achieve that purpose is our second question. So again, we would have to ask, is the restriction that has been used, is that now actually able to achieve the stated purpose? Because only then does this restriction make sense. Otherwise, it would be useless. So the restriction must be related to the purpose and must contribute to that specified purpose. If there is no connection whatsoever, so for example, if the government collects a lot of data, but they don't use it to protect cybersecurity, but maybe to put people under surveillance for other purposes, but then that would not be meeting this test. So this test of ability to achieve the purpose asks the question, is the data here used for the specified purpose? Only then it contributes to the specified purpose. Otherwise, it would be used for, you can say, other nice things from the perspective of the government. But we have to be very clear here that if we state a certain purpose, then all the measures that we use must be connected to that purpose. Therefore, the restriction, the collection, and the use of data must be connected to a certain purpose, and that, in order to make sure, that is now maybe the first, you can say, way how these pieces of legislation can be drafted is, we can, for example, earmark data. We can say this data has been collected for that purpose and can only be used for that purpose. So if state authorities collect data, they should have a procedure to market the data. This has been collected according to that provision, and that provision allows this purpose. This collected data has been collected according to that provision, and that allows this purpose. So that indeed the data is always only used for the purpose that has been allowed by the law, and not that all data gets in one big pool and then everything is used for all purposes. That would not be, you could say, respecting the specified purpose. So that should be made sure which data should be used for which purpose. That is the first step here already on the level of ability. So is the specified restriction actually connected to the specified purpose, or was the data collected and then has not been used for the specified purpose? That would be a violation already. Now, step number 3 is whether the restriction was necessary. So the data collection or the use of the data must be the least restrictive measure to achieve that purpose. So if there are other alternatives possible to also protect cybersecurity, national security, military security, and all these measures that could be alternatives and they would be less restrictive, then such measures would need to be taken. So the state, under the principle of proportionality, is forced to think of possible alternatives. So, for example, what could be other measures? I can give you an example with regard to the provision that we have mentioned in the Computer Crime Act, the general retention of data for 90 days. That is basically a measure that targets the whole population regardless of any suspicion against an individual person. And we will consider that a very severe restriction of individual rights because it is targeting everyone without any specification for any suspect against an individual. Such a measure could, for example, be replaced by a so-called quick freeze procedure, which basically means in the case where there is a suspicion against a person, there is then a procedure to quickly have access to the data and then freeze it basically until there is a decision by a court, for example, that this data can be used so that the data does not get lost. So it is somehow stored in a safe place and that it doesn't get lost. That would be a possibility to basically have a more targeted collection of data, maybe making it not necessary to collect, first of all, the data of the whole population. However, then the government may very often say these other measures, they are not that useful. They are, for example, this quick freeze may come too late, then the data may already be gone. So governments always have the legitimate concern, and it is very legitimate, that they want to have effective tools. They want to be able to investigate as far as possible. And obviously in the argumentation of the government that usually goes into the direction of as much data as possible. Obviously that is a very legitimate position from their position because they are in charge of protecting the population and they want to do everything they can. However, we, from the perspective of, you can say, what is really necessary, we must ask, well, are there other measures which are clearly and substantially less promising or less useful? If that is the case, if other measures are clearly less promising and less useful, well then the state cannot be forced to use them. The state must be able to fulfill its tasks responsibly and must have the necessary tools for that. But for example, governments may also sometimes say, well, but other measures are just more expensive and our budgets are limited. And we could do other things, but this would be more expensive for us. So for example, if we have to have a procedure, this kind of quick freeze procedure, for example, or if we have other tools of accessing to data, or that is all more expensive. Well, there I would say that is true. The state budget is a concern. The state budget is limited. But I would say the question that we need to ask is, are the other measures really unacceptably more expensive? So is it really out of proportion to invest such an amount that would, you can say, restrict individual rights to a lesser extent, but produce still an acceptable result? So financial issues may play a role, but I think there should be a certain threshold, which is also, you can say, I mean, what does unacceptably mean? But it's still, I would say, the mere argument that something is more expensive is in itself not an argument to say that's not something we can use. Things may be more expensive if we want to achieve a higher protection of individual rights. It might then sometimes be necessary to invest more, but it would be in the interest to protect the constitutional rights of the people. So the question of this necessary and what is necessary to protect cybersecurity and national security. With regard to data, we would have to ask, for example, questions like how much data is really necessary? Governments have the tendency to collect a lot because they say, well, then we have it and then we might use it later, but at least we have it. But well, there we might ask the question, well, what is really necessary here? What is necessary to achieve that purpose that you are pursuing? Which kind of data is necessary? Do you really need access to content? Or maybe it's enough to have only access to the traffic data. Or maybe it's only enough to have access to the so-called, you can say, stock data. That means the contract data. Who has made a contract with the service provider, so not telling us really anything about the internet traffic. There are different kinds of data, and they are connected to different extents to an individual. So we know a lot about the person if we know the content of the communication. We know a little bit less about the person if we know only about, well, with whom had the person contact and what was, you can say, the time of the contact. And we know even less about the person if we only know what that person has a contract with such and such service provider. So we could indeed here ask the question, which data is really necessary for the purpose? And then a very important issue, and that is something that I would also draw your attention to when you read the Computer Crime Against the Cybersecurity Act, is who needs access to the data. That means who on the state side really needs access to the data and who is given access. So in these acts you sometimes find just the term, well, an official has the right to access this and that. And then the question is, well, who are these officials and with whom can they share their data? So then the Computer Crime Act, for example, also stipulates that officials are not allowed to disclose the information that they have received. But what does that mean? Does that mean disclose to the outside? Or does it include the government section? So are they, if they are the persons who have now collected the data, are only that civil servants the persons who are allowed to process the data? Or can they share with other civil servants and other government agencies, thereby already spreading the data a little bit more? So I would say state-of-the-art data protection always considers who must have access to the data and who does not need to have access. Within the government, that needs to be restricted. There needs to be a restricted access to data. So we cannot say, well, once we give the data to the government, then they can circulate it through all agencies. Obviously, the state is very much interested in that because it's very nice to have all the data. But if we want to have an effective protection of individual rights, we might have to say, this data for that purpose and for that person and for that official. That is a very useful restriction. And in that regard, we can also have certain procedures that make that sure. A very important procedure are court orders, and we have seen that the Computer Crime Act and also the Cybersecurity Act have these kind of safeguards. We might sometimes demand them a little bit more also in other cases because not all restrictions under these laws demand court orders, but some do, and I think that is very useful, so that a court, an independent court, must decide whether the official has access to the data or not. That is a good safeguard because the court, the judge, is a separate branch of government, the judicial branch that can exercise control over the executive branch. But then there are many important safeguards that could be introduced, and as far as I have seen, there might be even more chances to do that also in the current drafting process. For example, if data has been collected and used by the state, then there could be something like a mandatory notification of the person who has been the subject of such data collection, that the person knows afterwards, my data has been collected. Only then do you have the opportunity to file any remedies against that. Only then do you have the opportunity to ask the court whether that was actually legal. If you never know that your data has been collected, you will never have the opportunity to control that. So after that, after an intervention with your data, that means not within the investigation. Some investigations need to be secret by the state if they are investigating crimes. But after the end of an investigation, there should be a mandatory duty of the state to communicate to the individual, we collected this and that data from you for your information. And if you want to now file a remedy, you can do that. So Another procedure safeguard is if data is not necessary anymore to be used, it should be deleted. There should be safeguards and there should be certain so-called sunset clauses. That means how long can data be stored and when does it have to be deleted. That is also a very useful safeguard. How long may data be saved and used? That is connected to that. And then also certain rights on the parts of the individuals, that people have the right to information about the data that has been collected, that you can go to your government agency and ask, what did you collect about me? That you have access to that. Also the right to deletion, so that you can ask from government agencies, delete my data. You don't need it. That you have a certain, for example, a procedure in an administrative court that can make sure that data